Good afternoon, everybody. Just waiting for everyone to come through from the lobby. But good afternoon. Welcome to today's session. For those of you that have been along, probably a familiar face by now. Just in case this is your first session, I'm Manvi and I'm the Learning and Development Manager here at the MGAA. And on behalf of the MGAA, I'd like to welcome you to our session today about the impact of AI, hosted and supported by Mills and Reeve. Before we start, I'm just going to run through a couple of housekeeping points, probably very familiar to many of you. You'll notice that your camera and mic aren't enabled at the moment. It's just to maximise bandwidth and to avoid any disruption during the session. But we do have the option of enabling these when we get to Q&A, so you will be able to utilise them then. So please don't panic if you can't see that feature at the moment. Just a quick reminder that we don't have permission for AI note-taking tools. So if these are in the attendees list, I will have to remove them, and please don't turn any on. Throughout the session, we do encourage you to ask questions, and they are welcome. However, we do have a dedicated Q&A space at the end, so feel free to save your question till then. And you've got the option of a Q&A section if you want to share it there or via the chat. We are recording the session, and as always, we'll make this available post-session on our on-demand page, but also send a link out to everyone that has registered for the session. So please keep an eye on it. And if you do find this session meets your learning objectives, you can include this on your CPD log. And it's currently accredited by the CII for our content with these webinars. Before I hand over, I'm just going to quickly cover the learning objectives for today, which are to describe how AI is being used across key professional sectors and the types of PI claims and coverage issues that may arise as a result. Explain where liability may fall when AI contributes to these professional areas and how this may shape future claim trends. And then our last objective is to outline the key risks, practical implementation, challenges and best practice principles MGA should apply when integrating AI into their own operations. So those are the learning objectives to consider for your CPD log. That's all from me. So without further ado, I'm going to hand over to our presenters today, Paul and Sarah. I think, Sarah, I'm going to hand over to you in particular.
Thank you, Manvi. So thanks everybody for inviting us to speak today. As Manvi said, I'm Sarah Rose. I'm a Principal Associate in our Insurance Disputes team based in Manchester. I specialise in the defence of regulated professionals, and I'm part of the Future Proof team within the insurance disputes practice, which is a thought leadership campaign focusing on the impact of AI from a professional indemnity perspective. I'm joined today by Paul, who's a partner specialising in technology and commercial law, with a particular expertise in advising on all things AI. So as Manveen said, we're going to split today's session into two parts. I'll start by considering the impact of AI from the perspective of insurers of those adopting AI, where the risks lie and potential coverage issues. Paul will then move on to how AI might influence the MGA as a business and some practical considerations to bear in mind. I'm going to start very quickly setting the scene on what we mean by AI and generative AI. So on the slide, you'll see some key terms in the AI glossary. Artificial intelligence refers to machine-based systems that infer from the input they receive how to generate outputs, such as predictions, content, recommendations, or decisions. Different AI systems vary in their levels of autonomy and adaptiveness. So indeed, the predictive text technology on your phone is a form of AI. So you'll appreciate the definition of AI is very broad. Algorithms are the building blocks for AI. These are the instructions or rules written by a tech developer that the computer follows to complete a task. Machine learning is the branch of AI where computers apply the rules written. So they run the algorithms to learn from data and make decisions or predictions without being specifically programmed for each task. Deep learning is a subset of machine learning that uses complex algorithms called neural networks to learn from large amounts of data. So the large language models that you'll have heard about are deep learning models trained on a large amount of text data. Foundation models are deep learning models trained on large data sets, including text, images, and audio, to learn to perform various tasks, such as understanding text or recognizing images. Generative AI refers to systems that can create new content, so such as text, images, audio, and video. A generative AI system will nearly always use a foundation model or large language model. It is technically possible to build generative AI without foundation models or LLMs, but it's not common in modern systems because of the superior performance and flexibility that foundation models in particular offer. And finally, agentic AI is the latest buzz phrase and refers to autonomous AI systems that can make decisions and perform actions with minimal human intervention. So these agents are capable of understanding their environment, identifying the set of tools and functions at their disposal, and using those to take actions to achieve their objectives. Agent-based systems use foundation models to match their capabilities with their objectives. So, for example, an order processing system may have multiple agents autonomously capturing pricing and market-related data. When a request for an order is raised, the agentic system may utilize those prices, or, seeing that they haven't been updated recently, may use another agent to retrieve the latest price available. And this all happens automatically in the background because the system knows which agents can perform each task. So having covered those basics, how might AI start to change the law of professional negligence? But I think it would be remiss to entertain a talk on AI and the claims landscape without turning to the work of the UK Jurisdiction Task Force. This is an industry-led initiative tasked with promoting the use of English law and UK jurisdictions for technology and digital innovation. Members of the UKJT include the Master of the Rolls, numerous members of the judiciary, and various high-profile barristers. And last month, they published a much-awaited paper addressing various questions, including in what circumstances and on what legal basis will English common law impose liability for physical and economic loss caused by the use of AI? How does vicarious liability apply to loss caused by AI? And when can a professional be liable for using or failing to use AI in the provision of their services? There's not enough time today to go through the findings in detail. That's a whole talk of its own. But certainly my takeaway is that whilst there will clearly be a need for concepts to evolve, the reasonably competent lawyer might now involve an analysis of whether or not you should or shouldn't have used AI. Principles of remoteness of loss are going to be challenged. The role of the expert is going to need to be carefully considered. There's in fact no fundamental reason why the existing common law can't evolve to meet this new era of claims. So if that's the case, how are those claims likely to arise in practice, and what risks or benefits does the adoption of AI pose for insurers of professionals? So there's a common perception that the use of AI is likely to lead to a significant increase in the number of claims against professionals. But in fact, it could lead to fewer claims. So many of the claims that we see in the team at the moment arise from basic human error. And one of the big advantages of AI is that it can improve efficiency and productivity to potentially reduce some of those routine errors. Some examples across the various professional industries we have seen of adoption so far include, for accountants, predictive analytics, helping clients with trend forecasting, growth strategy and risk profiling, and audit support, so using large language models to extract and analyse data, generate insights, and connect hard data with internal knowledge bases. For lawyers, I think technology-assisted review for disclosure exercises has been around for quite some time now, but we're starting to see things like Kira for the analysis of contracts, and at the extreme end, Garfield Law, so an AI law firm which navigates the small claims debtor process, although expressly doesn't give any advice on the merits. And finally, with architects, from problem framing to concept to design, including examples such as digital twinning, where AI stimulates and optimizes a building's performance, including its environmental impact. And you'll have seen from the slide that the data is also clear. Across all professions, the rise of AI is being reflected in practice. So against that backdrop, key to mitigating risks is really understanding AI's limitations. I'm not going to try and cover every single risk, but we've taken sort of 6 of what we think are the main risks that are likely to occur. So turning first to IP infringement. AI systems are trained on vast data sets, which means that professionals using those tools may unknowingly use or reproduce copyright protected content, or be found to be infringing copyright because the output closely mimics existing copyright protected works. It's not necessarily possible to check for copyrighted material due to AI tools' reluctance to disclose the data sources that the LLMs have been trained on. So various leading architects and designers have opposed UK government plans to allow AI companies to train their models on copyrighted work without their consent. And although the government's plans include a right for creators to opt out of copyrighted material being used, critics would say that the approach is open to misuse and abuse. Bias issues. So generative AI models may repeat and potentially amplify any underlying biases in the data they use, and that could lead to discriminatory treatment of clients or staff. I think some of the most acute examples are going to arise in the healthcare sector, where social or physiological differences can make a significant impact on the likelihood of certain conditions arising, but it's certainly not limited to that professional discipline. So, for example, accountants using AI to advise clients on financial strategy and risk. If the AI being adopted by the accountant disproportionately flags minority-owned businesses as high risk due to biased data, that could result in claims. And data and confidentiality breaches. So the most obvious risk here is professionals inadvertently breaching client confidentiality by uploading commercially sensitive or confidential data onto a public or an unapproved AI platform, and processing client data using AI without proper consent from clients or safeguards in place will also pose a risk. So across the pond, the case of US and Hepner has been gaining a lot of attention recently. In that case, the defendant had input confidential information and draft defense strategy into Claude, a publicly available AI tool, and it was found that this had overridden confidentiality and privilege. We've also had UKNR and the Secretary of State for the Home Department in the Immigration Tribunal, where again a lawyer uploaded confidential client correspondence. It was found that had overridden privilege and needed a referral to the regulator. Cybersecurity and phishing. So there's an obvious issue of malicious actors using AI to conduct phishing schemes and other frauds. So in 2024, the British engineering firm Arup was a victim of a deepfake fraud after an employee in Hong Kong was tricked into sending £20 million to cyber criminals by an AI-generated video call. And apparently you now only need 3 seconds of audio to clone someone's voice using AI, so I have definitely already given more than enough. But there's also the risk that the use of the generative AI products themselves increases the risk of a cyber attack if the systems used by the professionals aren't sufficiently vetted and protected. Inaccuracy of outputs, hallucination, and over-reliance on outputs. So generative AI outputs are text predictions. They're based on patterns detected from the sources they're trained on. They don't think for themselves. And in most cases, the response you get doesn't explain how it's reached the answer. And it's also dependent on the quality of the question or the prompt, which can make a huge difference to the reliability of the output produced. And then there's the issue of hallucinations, where if the large language model can't find the answer, it will make it up, but in a really convincing way. So you likely all heard of the case of Allende and the London Borough of Haringey, where false case citations have been generated using public generative AI tools. The barrister acting denied having deliberately used generative AI to conduct legal research and then covering that up, but did accept that she might have inadvertently relied on generative AI responses to Google searches. And that led the judge to give a very stark warning that those who use AI to conduct legal research owe a professional duty to check the accuracy of that research before using it to advise clients or before the court. In short, you can't rely on the output of generative AI without proper checks and balances in place. And that leads quite naturally onto regulatory breaches. So as things stand, none of the main regulators for professionals in the UK have in place specific conduct rules for AI, but many, including RICS, the SRA and the Bar Council, have started to offer guidance, which is likely to then form part of the court's assessment of what the reasonably competent professional ought to have done. And as of the 9th of March this year, there are now mandatory requirements for RICS members to follow when using generative AI, which required the surveyor to carry out due diligence over the data security aspects of the AI product and its suitability as a tool, and to create a risk register which records the risks associated with AI and how those risks are to be managed. So finally, I wanted to move on to coverage and touch on the issues that might arise if we see claims coming through from the use of AI. So the first question is, what type of policy might be engaged? Well, most professional firms hold a range of policies that could be triggered by AI-related claims, and there are some examples on the slides here. So for example, a cyber policy might respond to an AI-driven attack. A D&O policy might respond if it's the directors or officers engaging AI in the decision-making processes. EPL policies might respond if there's a discrimination claim arising from a biased AI recruitment tool. IP policies could respond to copyright or trademark breaches, and crime policies might respond to financial fraud committed using AI. So when considering cover, 3 questions are always asked: the scope of the insurance clause, any exclusions that might apply, and any other potential coverage issues. So what about the scope of the insuring clause? Well, we've just heard that the best trained models will make mistakes. They work on confidences of output and they're systemic. So the question really is not whether the claim arises from the use of AI, but how and in what context was it used. So most professional indemnity policies are written on a civil liability basis, meaning that subject to exclusions, they'll cover a broad range of claims, not just those arising from negligence. Others, like design and construct policies, may be narrower, covering only liability resulting from claims arising from any negligent act, error, or omission of the insured. I'm sure many of you will be familiar with the fact that solicitors and accountants' policies are quite broad in nature because of the minimum terms, but it's still going to be necessary to consider whether or not the insuring clause will respond. And some wordings, particularly those not subject to minimum terms, will require consideration of whether the tool that was used is considered a professional service, meaning covers more likely, or a product triggering potential exclusions. And that point comes into the fore, particularly where firms or professionals have developed their own bespoke AI tools, which they're then offering out to clients to use. So assuming it falls within the scope of the insuring clause, are there any exclusions that might apply? But there are reports coming through of AI-specific exclusions in the wider insurance market, but also affirmative cover for particular professionals. So for now, from a professional indemnity perspective, the common exclusions we think could apply are claims covered by other policies. So for example, cyber, crime, EPL, claims relating to goods or products sold by the insured, fines and penalties exclusions, or bodily injury or property damage exclusion. And what other coverage issues do we think could crop up? Well, there's the question of silent AI cover. So we need to be mindful of additional covers that are often included within policies. So for example, professional indemnity insurance often covers claims for unintentional copyright violations through the provision of professional services. In the absence of any provision stating otherwise, that extension would likely cover claims arising from breaches that were themselves caused by AI, if the AI was being used in the context of the provision of a professional service. Aggregation, will these claims be treated as one or many claims? We know that AI errors can be systemic, so one flaw in a model could lead to multiple claims. For example, if a solicitor uses AI to review leases, each lease could be reported on with the same error occurring in each lease report. Or an architect uses AI to design buildings, multiple buildings can be constructed, each with the same flaw originating from the design phase, but which wasn't immediately obvious at the outset. Would any of those claims aggregate? Well, under the minimum terms as they stand and following the decision in Access and Discovery Land, I think it's still going to be difficult to aggregate any claims the solicitor may face in that situation, even though the use of AI means the same error has been duplicated multiple times. But the situation may be very different under a policy with an originating cause aggregation clause, which are much broader in scope and where AI might be enough to be shown to be a unifying factor. And the duty of fair presentation. Given the risks associated with AI and generative AI in particular, without proper checks and balances in place, the way in which an insured uses AI and for what purpose may very well be considered material to the risk being underwritten. And it can actually be quite difficult for professionals to answer the forms properly and accurately if they don't really understand what they're doing. And that's where we think the problems could arise. So that leads to the questions that are posed in the proposal form becoming critical as to whether or not insurers would be left with a remedy under the Insurance Act. And assuming there is a claim that is covered that you do have to pay out on, what's the prospect of recovering against the AI provider if it's the tool that's at fault? Well, theoretically, we think it's possible, but pursuing it's not necessarily going to be easy. We've put on the slide some of the questions that will arise, and possibly one of the key things is going to be the contractual terms that the professional's been able to enter into with the AI provider. And that tends to suggest that recovery is more feasible if a firm's developed its own bespoke AI tool or implemented a private instance of an AI system, because in that situation, they're likely to have been able to negotiate stronger terms and obtain more assistance from the provider. So before I hand over to Paul, I just wanted to conclude with some observations from a more practical standpoint. As I mentioned earlier, the biggest sort of opportunity to know where the risk falls before inception is the proposal form. So as AI becomes more heavily integrated into the provision of professional services, we'd anticipate more questions arising in proposal forms around the business itself. So what governance is there around AI within the business? What policies are in place to ensure AI is being used ethically, responsibly, and in line with any regulatory guidelines? What data or cybersecurity measures are already in place? What's the involvement of humans? What's the supervision practice like? And actually, what's the IT infrastructure? What's the size of the IT spend, the extent of the IT specialists? Are there AI specialists in-house? And then from the AI specific sort of context, what's it being used for? What types of data are being put into the system and what safeguards are there in place around confidential and sensitive data? What training is received by employees to ensure that they're using AI tools effectively and responsibly? What verification processes are in place to check that AI output and also the data that's going into the system? Which platform is being used and how is it being selected? What's the approach to billing? Do clients even know that this is being used? And finally, that all-important question about the contractual arrangements. How likely is it that there would be scope for a recovery if a claim has to be made? And before handing over to Paul, I guess I would just say that our key takeaway in the future-proof team at Mills and Reeve has been one of hope and not of gloom. I think there are some really exciting opportunities that will hopefully drive efficiencies and productivity and feed into growth. And with proper guardrails and training in places, professionals will have an opportunity to provide more valuable, cost-effective and competent client-led services. And that has a prospect to reduce claims as much as it does to introduce a new risk area. It's fair to say we definitely don't have all the answers at this stage, and the rate of change that AI is developing with means that's perhaps not so surprising. But I am now going to hand over to Paul, who's going to take us to look more at the impact of AI for the MGA as a business.
Thanks very much, Sarah. So if we can move on, there we go. So I'm a technology and commercial law partner here at Mills and Reeve, as has been mentioned. That means I get to advise clients on their planned use of AI, help them develop internal policies, put in place appropriate contract terms governing use of AI when they're procuring or providing AI-related services. And as Sarah mentions, I want to look at how you as managing general agents may use AI systems and how to do so in a way that minimises the risk when you do so. So Sarah mentioned different elements of artificial intelligence, including generative AI systems that create new content in response to user prompts, and agentic AI systems that are given a set of capabilities and then autonomously select which of those are best suited to achieve an objective. Thinking about the work managing general agents do, we've mapped out some of the opportunities that appear to exist for exploiting what Gen AI and agentic AI can offer. You may well already be using AI systems for these purposes, or indeed others, and it would be very interesting to hear experiences of using AI systems you've got. I suppose generative AI systems that are getting good at giving contextual intelligence. So that could aid underwriting, for example. So you could use Gen AI systems to produce summaries of complex data or for pattern recognition across disparate data sources. When it comes to policy administration, you can imagine agentic AI systems helping endorsement processing with rule-based validation and with continuous monitoring for inconsistencies across endorsements and renewals. And generative AI could be used for automated correspondence, so generating renewal notices or requests for information, for example. And in the context of claims management, you could use agentic AI systems to route claims to the appropriate handlers and for initial coverage validation based on policy terms. And generative AI systems could be used to identify patterns or anomalies across claims that may indicate fraud or subrogation potential. Now, Sarah mentioned a couple of Thomson Reuters surveys. We've been canvassing opinions ourselves about generative AI in particular. So we've surveyed around 320 organisations from a variety of sources and sectors. And we've captured our findings in a report that we've called the Critical AI Window, Moving from Panic to Play with Confidence. We found that out of those 320-ish organisations, at the point of our survey last year, only 31% were currently using generative AI for business purposes, but 72% expected to be using it by 2027. So I think this indicates the adoption of generative AI for business purposes is increasing rapidly. And it kind of feels inevitable that if you don't embrace what Gen AI and agentic AI can offer, a competitor will, and they'll steal a march on you. But of course, when you're using generative AI systems, you need to be alive to the legal risks. So if we can move on, thank you. Sarah's touched on these already when considering where claims are likely to arise. But to reiterate and expand on what's already been said, the intellectual property rights infringement risk essentially arises if the model relied upon by the generative AI system's been trained on copyright protected work without permission, because if so, output could contain a substantial part of the works on which the system was trained. And you can also have a situation where the output generated in response to your prompt is the same as content generated following the same or a similar prompt by someone else. So when you're planning use of Gen AI systems, do ask for transparency over what data has been used to train the model. And it's reasonable to look for contractual protections, such as an indemnity against IPR infringement claims. Different AI providers are taking different stances on this. And the opportunity to negotiate will depend on whether you're taking an enterprise subscription or whether you're using a free-to-use open AI model such as ChatGPT, where you'll have no opportunity to negotiate, of course, and the terms will give no warranty of non-infringement. And actually, liability will be capped to $100 unless you paid more than that for their service. When it comes to confidentiality, it is possible to use generative AI systems without disclosing to others confidential information you want to input into the system. But to ensure that, you'll need an enterprise subscription that means data is not shared across different customers of the Gen AI system, with data being encrypted when it's transmitted and at rest, or with equivalent technical measures taken to ensure the data you input into the system is not going to be seen in the clear by other users or by IT support teams working for the tech provider. On the data protection front, if you're going to process personal data through a generative AI system, you need to be transparent about that, as individuals have a right to understand what's being done with their personal data. So the Information Commissioner's Office encourages the use of explainability statements, which should avoid being too technical, but should help people understand how their personal data will be stored, used, and adapted by algorithms within the generative AI system to generate content. We haven't actually seen many of these explainability statements in existence yet, though. And there are other data protection principles that can be challenging to comply with when personal data is being input into generative AI systems. For example, sometimes the purpose limitation principle can be difficult to meet, as that requires personal data to be collected for specified, explicit and legitimate purposes and not be used in a manner that's incompatible with those purposes. And AI tools and LLMs or foundation models arguably may use data for any purpose. There are also restrictions under the data protection legislation on automated decision making that has a legal effect or similar on individuals, although the rules on automated decision making have been revised recently by the Data Use and Access Act, and those new rules, which came into force in February, are more permissive than they were previously. When it comes to cybersecurity vulnerabilities, so Sarah's mentioned some, but I suppose AI systems face some unique challenges and risks beyond traditional software vulnerabilities. So for AI systems, there is a concept of data poisoning, which is where malicious data injected during training can corrupt models. And there have been examples of attackers reverse engineering models to steal IP or exploit weaknesses. And sometimes manipulated prompt queries can expose sensitive data. Sarah's mentioned the possibility of claims arising from inaccurate output, and we've heard about hallucinations, for example, with the cases being cited that didn't exist. At Mills and Reeve, we're encouraged to think of the generative AI systems we use as being like an enthusiastic, overconfident trainee solicitor. So they will give you an answer, and our trainee solicitors are great, but they won't always get the answer 100% correct. So they do need supervision. There is therefore quite a strong argument that you shouldn't really use Gen AI systems for anything that you are not capable of checking yourself. And this all means, of course, that it's important to take an interest in contractual terms or the terms of use that apply for particular generative AI products. But then that should be the case for any technology product you're contemplating using, really. And I would say that, wouldn't I, as a lawyer? But it also means, I suppose, that it's worth setting guardrails for use of Gen AI in your roles as managing general agents. So testing Gen AI products before committing to them is a must, and you really need to understand to what extent data might be shared across different users. So as I mentioned, an enterprise version should avoid data you input into the Gen AI system from being accessible to other users of the Gen AI system outside your business. Here at Mills and Reeve, we've tested over 50 different AI systems to date, and we've chosen to adopt only a handful of those. We recommend you have a policy that only approved Gen AI products can be used for business purposes, and make it clear how people within your business can seek approval to use other Gen AI products, because new products are coming onto the market all the time. And I know from experience that there's always someone who wants to use something that isn't on the approved product list. And we suggest setting some golden rules that get followed for use of Gen AI systems for work purposes. So the type of golden rules I would suggest include never share any information that's not already available in the public domain, nor personal data with an online available Gen AI model such as ChatGPT, because those models may use data to train their model, and that might mean that data can be accessed indirectly by other users. We'd say never use an online Gen AI model for work purposes unless the business has proved that model first, and always critically assess any response produced by GenAI for potential biases and factually inaccurate information, because remember, it should be treated as an overconfident, enthusiastic trainee. And we've got golden rules that you should always critically assess whether the output of GenAI is likely to infringe intellectual property rights, and that GenAI models shouldn't be used for critical and time-sensitive generation. That's because the likelihood of appropriate critical assessment being applied is perhaps reduced if under time pressure. And you should be able to evidence the human supervision of GenAI output, so appropriate assurance can be provided to clients, auditors, in my case, our insurers, etc. And for us, it's important to check there's no prohibition on using GenAI imposed by the relevant client in respect of work for them. So I put those out there as golden rules to contemplate adopting and implementing into your AI use policies. Before I finish up, I do just want to highlight what the position is in the EU when it comes to use of AI, because the EU's AI Act is considered the most comprehensive legislation currently regulating AI systems. And the way the EU AI Act works is to set out different rules that apply for different risk levels of AI system when they're being used in the EU. So the EU AI Act distinguishes between unacceptable risk systems, which are essentially banned, high-risk AI systems, and then other AI systems. High-risk AI systems include AI systems that are used in products falling under the EU's product safety legislation, which includes toys, cars, medical devices, lifts, and so on. And then they also include, the high-risk AI systems also include AI systems that fall within certain other specified areas that are listed in the legislation. I won't go through the entire list, but thinking about what might be most relevant to you, high-risk AI systems include AI systems used for recruitment or for work allocation, for employee performance and behavior monitoring, or for determining whether someone should be promoted or have their employment terminated. And high-risk AI systems also include AI systems intended to be used for risk assessment and pricing in relation to individuals in the case of life and health insurance. Other types of insurance aren't referred to in the list of high-risk AI systems. But if you're based in the EU and you're using a high-risk AI system in the EU, then you're obliged to do those things listed on the slide. So you have to follow the AI system's instructions for use, ensure competent and meaningful human oversight of the AI system. If you're in control of the input data, you need to make sure it isn't a load of rubbish, essentially. You need to monitor the system to make sure it's working as intended, and you need to train your staff to make sure that they have a reasonable level of AI literacy. Now, doing these things sounds like a good idea, even for those of us that are not obliged to comply with the EU AI Act. So I'm flagging these points to build upon the safeguards I've already mentioned as being worthwhile elements of your AI use policies. And perhaps now that we've set the scene, as it were, in relation to the likely impact of AI on the claims landscape and on the business opportunities and risks that AI systems, especially generative AI, present, I guess it must be time to open up the floor to questions. I haven't spotted anything go into the chat, but Manveen, have we got any questions that have arisen? If not, does anyone have anything they want to ask?
No questions have come through yet. I'm going to enable mics and cameras should anyone want to ask Sarah and Paul directly. So feel free to raise your hand. We do have two options of submitting questions, actually. I've got a Q&A and a chat option, so whatever anyone finds easier. Please do feel free to use either or. Give it a moment just in case any questions do come through.
everybody's ready for their Easter break, Manveen. Hopefully.
Well, that, or you've obviously addressed any questions that have cropped up without realising. So can't see any questions come through. So I'm going to assume that we don't have any for today's session, which is not, not a terrible thing. But I can see you've shared a QR code, so I'm going to hand back to you if you want to just quickly cover this slide, and we can see if any questions come through in the interim as well.
Yeah, great. Thanks, Manveen. And obviously, if there are any questions anybody thinks of afterwards and wants to pick up directly, feel free to message me or Paul, and we'll make sure to come back to you. This slide is just to say that if you are interested in our Future Proof campaign, then if you follow the QR code, you'll be able to find out more. Be taken to the website, you can sign up for our updates, and you'll get added to our mailing list for our future webinars and things. But yeah, I can't see anything else that's come in, so I think that is probably it from us. But yeah, please do feel free to reach out with any questions, and we're more than happy to address them.
Fantastic. And obviously, if anyone, no, thank you, Pamela, no problem at all. Obviously, if we just go back to that first slide, just in case anyone wants to capture your details,
Yeah.
unless you've got, there we go. I think see you've got them at the end as well.
Oh, have we? Let's skip through. There we go.
There's the QR codes. Obviously, if anyone has any difficulty in getting in touch with Sarah or Paul, you can always email myself or the member services here at the MGAA, and we're happy to put you in touch. I think we'll wrap up there for anyone looking to kind of put their out of office on early today. As always, please do let us know any feedback you have for us. You can do that on the survey link I've just dropped into the chat. Otherwise, thank you to Paul and Sarah for their session today, and thank you all for joining us as always, and have a lovely long weekend, everybody.
Thanks, everyone.
Thank you, everyone.
Thank you.
Thanks all.